In the United States, where this lawsuit is pending, it's very difficult to sue a journalist. The New York Times is coming back and saying, look, we're not Blake Lively. We're not the ones making the allegation. We're just fairly reporting on what Blake is suing Justin and Wayfarer for.
Justin Baldoni is suing the New York Times for defamation, alleging that the newspaper crossed a critical line between objective reporting and outright advocacy. According to Baldoni, the Times didn't just cover claims made against him by an individual called Lively. It presented those claims as cold, hard facts, complete with a companion video suggesting it had discovered the absolute truth. Now, this case raises urgent questions about journalistic integrity and where fair report ends and defamation begins. Even if Baldoni doesn't secure a massive payout, his lawsuit could redefine how public figures and media outlets clash in the court of public opinion.
That Baldoni had engaged in improvised and unwanted kissing. In one message to the publicist, Nathan wrote, "Socials are really ramping up in his favor. She must be furious."
If you find this topic as compelling as we do, please click like, subscribe to our channel, and turn on notifications so you don't miss any updates on Baldoni's legal battle or other high-stakes cases shaping the entertainment industry. Your support helps us continue bringing you in-depth reporting and analysis. The lawsuit springs from an article and video titled with the ominous phrase, "We can bury anyone." This piece discussed Lively's misconduct allegations tied to a film project involving Baldoni. Normally, media outlets protect themselves by framing controversial assertions as alleged or reported, but Baldoni's legal team insists the New York Times went further. In fact, one of its journalists appeared on camera, claiming they knew what really happened, hinting at thousands of documents supposedly backing that story. Baldoni contends these were taken out of context or were incomplete, painting him in a false light. Adding fuel to the fire, Baldoni says he was only notified hours before publication, too little time to provide a comprehensive response. Although the Times noted it attempted to reach out, there's a lingering suggestion that it never planned to incorporate his side fairly. Many in Hollywood are watching how this might alter the press-celebrity dynamic. If Baldoni proves they rushed a flawed narrative, the public may never view such exposés in the same light.
But this story reveals a new playbook for waging a far-reaching and largely undetectable smear campaign.
Pivotal piece of Baldoni's argument centers on the video accompanying the article. In it, the on-screen journalist states that, based on thousands of pages of documents, the Times has supposedly uncovered exactly what really happened. Baldoni's legal team regards this as the biggest red flag. By framing Lively's story as established fact rather than a series of allegations, the Times potentially crossed the line that separates unbiased reporting from adopting a singular, contested narrative as truth. Here's the problem. Defamation law typically doesn't punish honest mistakes or coverage of valid public controversies. However, Baldoni's attorneys point out that using terms like "we've uncovered" or "this is what truly took place" implies the newspaper conducted a conclusive investigation, one that left no room for doubt. This, they argue, places the Times directly behind Lively's accusations, rather than merely reporting them. If evidence later shows the Times selectively quoted from text messages or omitted contrary viewpoints, a court could see that as reckless disregard for the truth. In simple terms, the Times might lose the fair report privilege that would ordinarily shield them from liability. To bolster their case, Baldoni's team claims the Times only gave them a few short hours before publication to respond or refute the allegations, which itself is a common tactic known as ambush journalism. When asked why the newspaper would rush such a delicate piece, Baldoni's attorneys speculate that it was timed for maximum impact, dropping the story before he could produce exculpatory evidence. Whether this was a deliberate move to secure a juicy headline or simply an editorial decision gone awry could be a point of contention if the lawsuit proceeds to trial. Yet the video's tone may hold the key. The journalist's presentation, as Baldoni argues, went beyond typical disclaimers like allegedly or reportedly and used definitive language. This can sway public opinion and leave the accused party scrambling to clear their name in a climate of immediate suspicion. Observers note that, in an era where viral sound bites shape reputations, presenting allegations as established facts can cause irreversible harm, something defamation laws aim to prevent.
Look, even if everything he said about us is true, it does not amount to a legal cause of action. And we're proven to a jury, we could not be held liable for it because we're a journalistic outlet and we have this fair reporting privilege and other defenses that we're raising.
Although the lawsuit is filed in New York, where the New York Times is headquartered, Baldoni's attorneys are bringing up California law. They argue that false light protections recognized in California are pivotal to his complaint. Under false light, a plaintiff doesn't have to prove outright falsity of statements. It can be enough to show that the overall portrayal was misleading or place them in a harmful spotlight. This is especially relevant because Baldoni is based in California and works primarily with West Coast film projects. By tying the lawsuit to California's jurisdiction, his team contends the emotional and reputational damage inflicted by the article was felt most acutely in Los Angeles, the heart of his career. Media law experts point out that if a judge decides California law applies, it broadens the scope for what might be considered defamation or harmful misrepresentation. That's critical for celebrities who often feel they have limited options when a major publication airs damaging claims. The Times, meanwhile, is likely to argue that since publication originated in New York and the media giant is based there, New York's narrower defamation statutes should govern the dispute. New York typically requires a higher threshold of proof for plaintiffs, especially for public figures like Baldoni, who must show actual malice. But if the California standard is allowed to gain traction, the lawsuit could break new ground. It could become a rare instance where West Coast legal principles challenge how East Coast media outlets publish potentially damaging celebrity stories. This tug-of-war between two states underscores a broader evolution in media law. In an internet age where readers click from around the globe, pinning down one jurisdiction has grown more complex. Every story has the potential to publish simultaneously in every state and beyond. Baldoni's legal maneuver to have California's false light rules apply may signal a future wave of litigants who no longer accept that their only option is to fight battles on New York's legal turf.
There are a variety of methods that have long been used: gossip columns, tabloids, strategic interviews, public opinion about celebrities.
As the lawsuit continues, rumors abound regarding potential coordination between Lively and certain journalists within the New York Times. Baldoni's team hints there may have been a partnership designed to amplify Lively's accusations for maximum media impact. Supporters of Baldoni are calling for an in-depth look at the article's editorial timeline. When did the Times first receive Lively's evidence? And how much time did the paper realistically allow Baldoni to gather a defense? One particularly contentious point is the alleged noon deadline. Baldoni's representatives say the Times promised to hold publication until midday so he could prepare a coherent rebuttal. Instead, the article apparently went live earlier, arguably blindsiding his camp. That move, they claim, indicates the Times had little interest in balance or fact-checking and was determined to push a sensational story before Baldoni's side could disrupt it. These sorts of maneuvers, if proven in court, could tilt the sympathy of a judge or jury. Defamation suits against major outlets seldom succeed, but one factor that can tip the balance is evidence of deliberate recklessness or malice. By showcasing internal emails or editorial logs, assuming they're obtained during discovery, Baldoni's lawyers might unearth proof that editors or reporters ignored red flags just to publish fast. If that's the case, it could meet the actual malice standard public figures are typically required to prove. Observers note that Hollywood can be a swirling vortex of alliances and agendas. Whether Lively's motivations are purely personal or part of a broader strategy remains speculative. However, if Baldoni can show the Times knowingly participated in a campaign to harm his reputation, then "we can bury anyone" might become an ironic confession of how powerful media can bury or bolster specific narratives, particularly if they bypass fundamental journalistic checks.
The reason why they want to do this so quickly is that they don't want the target to come over the top. Blake Lively's aligned with New York Times. Justin and Wayfarer might have aligned with another media outlet. They never want that happening, so that's why they don't give the target any meaningful opportunity to do it.
Even with compelling evidence, Baldoni faces an uphill climb. American courts place immense value on the freedom of the press, recognizing that robust journalism often involves investigating thorny, unproven allegations. This latitude is meant to protect the public's right to be informed about matters of interest, even if some details remain in dispute. Yet Baldoni's legal argument aims squarely at the Times' methodology and claims of certainty. By labeling the story as fact rather than an open allegation, did the Times effectively endorse Lively's narrative without verifying all sides? His attorneys will likely highlight every moment the journalist used decisive phrasing. Phrases like, "This is what really took place," or "Our investigation proves." If the court agrees such language indicated reckless disregard for any alternative viewpoint, the Times could be in hot water. Some legal observers compare the case to previous high-profile defamation actions, where celebrity plaintiffs exposed media outlets that championed unsubstantiated claims. While results have varied, those cases remind us that, occasionally, even major news organizations can lose if the plaintiff shows enough disregard for truth or verification procedures. If Baldoni can do so, especially with tangible records or contradictory text messages, the Times may confront a rare but significant legal setback. Still, critics argue that punishing the Times might set a chilling precedent. They warn that if news outlets must parse each word too carefully, investigative journalism could suffer. Yet supporters of Baldoni insist that no matter how free the press should be, it cannot brand speculation as facts without thorough corroboration, particularly when someone's livelihood and reputation are on the line.
Well, and the irony of the title, right, Chris? We can bury anyone inside the Hollywood smear machine. The hypocrisy that Blake and the New York Times were doing the same exact thing. I mean,
when celebrities clash with top-tier publications, the ripple effects can be enormous. Websites, podcasts, and entertainment bloggers have all jumped on the story, debating motives and alliances. Some suspect Lively timed her revelations to coincide with a broader cultural moment, ensuring the public was already sensitive to claims of misconduct in Hollywood. Others question whether the Times seized a sensational angle for clicks, especially in a crowded media environment where big headlines equate to higher traffic. Complicating matters, social media has begun digging up older interactions between Baldoni and Lively, trying to piece together a timeline that fits this new narrative. Armchair sleuths point to interviews or behind-the-scenes footage from their project, reading subtext into every gesture or comment. Baldoni, however, has mostly refrained from engaging on these speculative platforms, likely on his lawyer's advice. Each statement he makes could end up dissected in the press or reappear in court documents. Meanwhile, the phrase, "we can bury anyone," has turned into a rallying cry for those who feel mainstream outlets sometimes wield their power irresponsibly. Hashtags referencing the lawsuit surface regularly on social media, painting the Times as an unchecked giant facing overdue accountability. Whether or not this is a fair portrayal, it highlights the uneasy relationship between celebrities, who rely on press coverage for career longevity, and media gatekeepers, who can quickly transform them into pariahs. Still, not everyone is on Baldoni's side. Some insist the Times is simply fulfilling its duty to report on an important story involving possible misconduct, and that referencing new evidence is not inherently defamatory. They view the lawsuit as an attempt to muzzle journalism, a tactic occasionally used by high-profile individuals to stifle negative coverage, all of which sets the stage for an intensely polarizing trial, if it gets that far.
Is that, hey, I'm a California guy. My company, I guess, is California. All these other people are in California. You, New York Times, based in New York, knew that publishing this story would impact me and others in California.
Baldoni versus the New York Times could redefine the lines between First Amendment protections and personal reputation. If the court finds that the Times moved beyond neutral reporting and improperly vouched for Lively's allegations as indisputable fact, it might pave the way for more lawsuits from public figures who feel similarly wronged. Yet, if the lawsuit collapses, it will reinforce the prevailing view that major outlets can, in good faith, report on lawsuits and controversies without facing crippling legal risks. There's a real possibility this battle never goes before a jury. High-stakes defamation cases often settle quietly, with private terms that let both sides claim some measure of victory. But even a confidential settlement could speak volumes about the vulnerability of media organizations when confronted by determined plaintiffs. Until then, each legal filing and piece of leaked evidence only raises more questions about what truly happened behind closed doors at both the Times and on Baldoni's set. And as the case unfolds, it shines a fresh light on an essential issue. In a world of fierce competition for scoops and sensational stories, do headlines sometimes outrun the truth? It's a dilemma faced by every newsroom, balancing the duty to inform with the responsibility not to destroy reputations on shaky grounds. For Hollywood watchers, the outcome of Baldoni's legal offensive may forever alter the power dynamic between Tinseltown and America's most esteemed newspapers. For Baldoni, one thing is certain. This lawsuit is not merely about clearing his name. It's also about drawing a line in the sand, demanding that even storied institutions like the New York Times answer for how they frame and sometimes inflame serious allegations. Meanwhile, those who've long criticized celebrity-driven gotcha journalism see the case as a catalyst for overdue reforms. Whether that reform materializes depends on what emerges during discovery and, ultimately, what the courts decide about who truly crossed the line and when.